Hello, everyone, and welcome to the Jeffrey Epstein Show. I'm your host, Bobbycapucci, and this is a bonus episode. Recently, the Second Circuit Court of Appeals heard from all interested parties about keeping the documents sealed or unsealing them. Well, today, they have made their decision, and the Second Circuit Court of Appeals has decided to affirm Judge Preska's initial ruling and keep the documents unsealed. So now the question becomes, when will those documents be dumped and when will they be available for the public? Obviously, we're going to keep on top of that, and the second that they become available, we'll have them and we'll go through them and we'll talk about them, obviously, and maybe we'll even do a sort of free-for-all kind of episode where we go through and read portions of the deposition and stuff like that. I haven't really figured out how I'm going to approach the deposition yet, but we'll definitely be talking about it, and we're going to read from the document itself. So that's going to be pretty interesting to see what is in this deposition, and then to play the guessing game, what did Ghislaine Maxwell get charged with perjury for lying about? I'm sure there'll be an assorted number of other mysteries for us to unravel as well, but until we get to that point, let's jump into this article from Law and Crime and see what they think about the ruling. Ghislaine Maxwell's allegedly perjurious 2016 deposition about Jeffrey Epstein won't be secret for much longer. Author of this article is Colin Combacher. A secret, years-old, and potentially damaging deposition from alleged sex trafficker, co-conspirator, fellow child abuser, general all-around scuzzbag, and bipedal serpent Ghislaine Maxwell must be released to the public, a federal appeals court in New York City ruled on Monday. Now, when the hearing first happened, remember, I told you I wasn't leaning one way or the other. I honestly didn't know how to call it by the way the judges conducted that hearing. They really let all sides have it. And then I don't think that David Boies had his best foot forward during this hearing either. And I know he's a well-decorated lawyer and a good lawyer, but it didn't seem like it was his day. So I really wasn't sure which way things were going to go. And then once we got to a point where the hearing was ending, I really had no idea. But it seems like the key was that they wanted to make sure that all parties agreed that these documents were judicial documents. And I think that was the sticking point for the Second Circuit Court, and that's what eventually led to them unsealing this stuff, or affirming Preska's original ruling anyway. Because if these are judicial documents, and they are, then the public has a vested interest in what they contain. So I think that's what ended up being what put this over the finish line to get this deposition released to the public. Jeffrey Epstein's longtime girlfriend, debatable at best, let's call her longtime associate, an alleged co-conspirator, fellow child abuser, general all-around scuzzbag, and bipedal serpent, unsuccessfully attempted to block the publication of her deposition from a 2015 lawsuit in which Virginia Roberts accused the couple of sex trafficking her during the early 2000s. So again, it's very important to point out that this is the deposition that Maxwell perjured herself in, and therefore that means that the prosecution believes Virginia enough where they have enough information and enough credible evidence that they charged her with this. So that means that they think this whole deposition, for the most part, is credible, right? That's what we have to go on here. So if you're named in this deposition, if you're John Doe or John Doe 1, or John Doe 2, and you're one of the people brought up in this deposition, it is bad news for you. We're talking about a disaster, pretty much a disaster at this point, right? If you're named in this document after it's one of the focal points of the Maxwell charges, I would have to think that that is a little bit more than circumstantial evidence at this point. And if the investigation is going where they say it's going and where we think it's going, then that John Doe 1 and John Doe 2 are definitely at risk of being one of those sealed indictments. Now, that's all speculation on my part, right? But you would think that if this deposition carried so much weight, that it was used to get these charges, these placeholder charges slapped on Ghislaine, then you gotta think that this deposition is pretty powerful and what it contains is explosive. Maxwell's attorneys sought to seal exactly 418 pages of her testimony by arguing that it would unfairly prejudice the jury in her upcoming criminal trial over sex trafficking charge after a lower court authorized the deposition's disclosure earlier this year. Again, I think that Preska has done a phenomenal job throughout this whole entire thing. And the way she handled Mr. I Kept My Underpants on Dershowitz and his lawyers was brilliant. She was able to really manage this situation, navigate this situation, and bring it to a point where we might actually see some justice. And I think when we have a situation where the justice system as a whole is such a dumpster fire, it's nice to see at least one lawyer is doing their job. It's nice to see at least one lawyer is looking at the evidence and making decisions. Because Preska and what she has done here has been pretty damn brave, folks. I don't think she gets enough credit. And she's been hammered a lot by a lot of people. And don't get it twisted. Again, I don't trust any of these people as far as I can throw them, right? I'm all about action, not words. But from Preska's actions and the way that she has conducted her part of this case, I think she should get a nod of the head, a tip of the hat, right? For, at the very least, making things fair and pursuing the law the way that it should be pursued. The deposition itself has been referenced by federal prosecutors in order to make their case against Epstein's right-hand woman in her indictment from June of this year. According to the prosecution, Maxwell perjured herself during the deposition by denying any and all knowledge of Epstein's sex trafficking organization. And that's huge. That is huge right there, because once they make her part of it, right? Once they say that she had knowledge of it, she was partaking in it, she was helping facilitate it, then we can go nowhere else but this being a conspiracy. You cannot have a conspiracy of one. That is impossible. There has to be multiple people involved, or at least two people involved, with a criminal act for it to be a conspiracy. And that's exactly what we have here. We have a RICO case in everything but name. All of the evidence we have here, all of these charges, all lead to one destination, folks, in my opinion, and that destination is RICO. And when this deposition comes out, if Julie Brown's reporting was enough to get the investigation kicked into overdrive, what's the deposition going to do when people can read it for themselves, read the court document for themselves, the words on the page, the words on the computer screen? You folks out there don't need a middleman to explain to you what's real and what's not, what's true and what's BS. And the second this document becomes available and people have it in their hands and they can read it for themselves, it's going to become even that more real, even that more explosive. Now, again, for those of us who have followed this case and for those of us who have been covering it and diving deep into it, there's going to be a lot of things we already know in that deposition, in the sealed documents. But when you have it in your hand and you can print it out as a PDF and it's released to the public for public consumption, for public discussion, it becomes a lot more real and it becomes a lot more powerful. And I think that's what we're going to see here for sure. Defendant Ghislaine Maxwell appeals from a July 23, 2020 order unsealing certain litigation materials, including and related to Maxwell's April 2016 deposition transcript. The court's brief order summarizes: She argues that the district court abused its discretion in ordering the unsealing of the deposition materials. Again, what have I been talking to you folks about and trying to hammer home? Technicalities and loopholes. That's what they're talking about here, right? It's just always technicalities, always loopholes, always, well, it's because of the process. That's why we have to get this thrown out. It's never because my client is innocent. And it's the same old nonsense, right? It is the same old nonsense. The order continues. Specifically, she argues that there is a lower presumption of access to the deposition materials at issue in this case than to the summary judgment materials we ordered unsealed in a similar case in 2019, and that her interests outweigh the public's interests. And remember, before we had their hearing, I was talking about the precedent that very courtroom had set by releasing the Jeffrey Epstein documents, by unsealing the 2,000 pages. And when a court sets a precedent such as that, it's very hard for them to go against a ruling, a precedent that they themselves have already set. And that was one thing and one reason why I thought that we had a good shot of getting this stuff unsealed, as long as the lawyers were competent and the argument was made correctly before the judges. So we're seeing that now for sure. They're pointing to that precedent. They're pointing to the fact that those 2,000 pages were already sealed, and that is something that weighed strongly in their decision. The argument evidently went nowhere with the 3-judge panel of the U.S. Court of Appeals for the Second Circuit on Monday. Yeah, they sniffed it out. They understood. They knew already because they had already been through this, right? The arguments made by Mueller were not going to cut it, even though he did a good job. The district court correctly held the deposition materials are judicial documents to which the presumption of public access attaches, and did not abuse its discretion in rejecting Maxwell's meritless arguments that her interests superseded the presumption of access. So they basically just took a razor blade to Maxwell's argument right there in their brief afterwards, after the fact. They just chopped her up with a Ginsu knife. Meritless arguments, talking about how she thinks her interest supersedes that of the presumption of access. And there was just, again, once they set that precedent early on with Epstein in 2019 in this very courtroom, it would be very, very difficult and hard for me to fathom how they would go back on that ruling. It would be a huge leap. Monday's order from the Second Circuit is part and parcel of a lengthy and ongoing search for the truth regarding Epstein and his associates that generally began in earnest and specifically began in court when the Miami Herald and their star reporter, Julie K. Brown, began poking around, suing to obtain information about the late financier, pedophiles, alleged global sex trafficking empire dedicated to servicing the wealthy with young girls. Well, I wouldn't go that far with the Julie Brown investigation. She doesn't seem to be interested in several angles of the case. She only seemed to have interest once she thought that she could, add a political scalp to her bedpost. And that was what initiated her investigation. And look, don't get me wrong. I've said this a million times. That's cool with me. Whatever gets the ball rolling is fine with me. But let's be honest about it, okay? Let's not act like she was out here as an advocate for these survivors and that was what her main motivation. The 2019 case cited by Maxwell's attorneys and the panel was initiated by Brown and the Herald. In that instance, a victory for the plaintiffs, the Second Circuit, outlined the beginning of the still-in-progress process underway in the Southern District of New York, whereby many of those long-awaited Epstein files are being released to satisfy the public's interest in the case while making pains and redactions to safeguard some third parties' privacy interests. Again, we're going to see redactions. There's no doubt about it. But I don't know the amount of redactions we're going to see. I have a funny feeling we're going to get a lot here unredacted. I think that the courts have had enough, and there is a serious public outcry for this to be put into the public sphere. It is that important, right? It is that there's that much public interest in this case because of the different realms of power that it touched, the different areas of control where it had its tentacles planted. We have some of the most powerful, wealthy people in the world involved in this shit. A child sex trafficking ring, and up until recently, the only people in jail are the prison guards who were watching Epstein. It's inconceivable. It's unacceptable. And that is why the public, you, has been so adamant that this case be prosecuted in the correct manner. And folks, again, it's because of your incredible amount of publicity that you guys are putting on this case and, sharing it with your friends, et cetera, that there's movement here. For decades, there was nothing. And then all of a sudden, people start getting interested. People start becoming alarmed about what happened, and people start demanding justice, and now we start seeing the wheels turn. What, that's a coincidence? No, it is not. Brown noted her latest legal victory against Maxwell. Then it's one of Julie K. Brown's tweets talking about how she won, and Ghislaine Maxwell loses the fight to keep her Jeffrey Epstein testimony sealed. The loss for Epstein's alleged groomer, co-conspirator, fellow child abuser, general all-around scuzzbag and bipedal serpent, and occasional pilot was actually twofold. So this is significant here, folks. This is a big part of this ruling as well. Apart from the headline-catching deposition issue, the defendant lost her bid to consolidate her appeal in the civil case with her pending appeal in her criminal case. Not a particularly important ruling for Maxwell's overall legal efforts one way or another, but a decision that means her legal costs and efforts are likely to remain inordinately high and spread thin. So she has to battle on two fronts. She can't consolidate the cases. She has to have lawyers overseeing the civil and the criminal portions of this case, different law teams. So that's going to take a pretty penny out of her bank account. And my question still is, how is she paying for all of this? Why are her assets not frozen yet? And if they do freeze her assets and she has no access to all of her money as opposed to maybe just one account or two, then who is stepping up and paying for it? Is it Scott Borgerson? Is it somebody else? I think that should be a matter of public record as well, because I think whoever it is, that person probably has some explaining to do also. We have reviewed all of the arguments raised by defendant appellate Maxwell on appeal and find them to be without merit, the panel wrote in their unsigned opinion. We deny the motion to consolidate this appeal with a pending appeal in the United States versus Maxwell. So we talked about it, and I really was not sure. So this is kind of a pleasant surprise to me that this has come down this way, this soon, and that this panel of judges has ruled in the manner that they have. I thought that it might take a little while longer, maybe another week and a half, but no, they heard enough. They came to the conclusion that these were, in fact, judicial documents, thus making them part of the public conversation. And that was the crux of the whole entire thing. Maxwell's lawyers tried to unsuccessfully argue that these couldn't be released to public because of the presumption of privacy. But once they are judicial documents in our society, unless they are put under seal by the judge, then they become part of the record. So now that these are unsealed, the deposition and the relating documents, I am very, very interested to see where we go, what they contain, and how they tie up some of the loose ends. Because I think we might get a few questions answered, right? Some of our, different threads that we're following, different storylines that we're following. We might get some more context. And of course, we're going to find a few nuggets of gold like always. So there you have it, folks. The Second Circuit Court of Appeals makes their ruling. They affirm Preska's decision. And it's another win for the good guys. Maxwell gets to sit in her cell and sulk. Her lawyers have to go back to the drawing board. And the wheels of justice inch just that much closer to the finish line. If you'd like to contact me, you can do that at bobbycapucci@protonmail.com. That's BOBBYCAPUCCI at protonmail.com. You can also find me on Twitter at BOBBY_CAPUCCI. All of the links that go with this episode can be found in the description box. All right, folks, we'll be back tomorrow with the morning update, unless something else cracks off tonight and I have to come back with another bonus episode. So, unless that unfolds, I'll be back tomorrow morning and we'll pick up on this.